Hello everyone, welcome to Law and Obligations and Contracts. For today's video, we will discuss about the different kinds of obligations. First, let us classify obligations. Under the law, we have primary classification and secondary classification. For primary classification, the following are the kinds of obligations. Number one, pure and conditional obligations. Number two, obligations with a period. Number three, alternative and facultative obligations. Number four, joint and solidary obligations. Number five, divisible and indivisible obligations. And lastly, obligations with a penal clause. For secondary classification, we have unilateral and bilateral obligations, real and personal obligations, determinate and generic obligations, civil and natural obligations, and legal, conventional, and penal obligations. But for tonight's session, we will discuss first pure and conditional obligations, which is covered by Articles 1179 to 1192 of the new Civil Code of the Philippines. Pure and conditional obligations. Pure obligation is one which is not subject to any condition and no specific date is mentioned for its fulfillment and is therefore immediately demandable. Example, Mr. D obliges himself to pay 2,000 to Miss C. As you can see in the given example, there is no condition or a specific date mentioned in the obligation. Therefore, this kind of obligation is a pure obligation. A conditional obligation is one whose consequences are subject in one way or another to the fulfillment of a condition. First, what is a condition? It is a future and uncertain event upon the happening of which the effectivity or extinguishment of an obligation or right subject to it depends. So, let us discuss the characteristics of a condition. Number one, based on the definition given, it is a future and uncertain event, which means that the obligation must happen in the future and that its happening is not certain, meaning you are not sure if the condition or the event will happen in the future. Second, it may be a past event, but it must be unknown to the parties. A condition may refer to a past event unknown to the parties if it refers to a future event. Both its very occurrence and the time of such occurrence must be uncertain. Otherwise, it is not a condition. And lastly, a condition must not be impossible. We will learn later why a condition should not be impossible. But first, let us discuss the two principal kinds of condition. One, suspensive condition. Suspensive condition is one, the fulfillment of which will give rise to an obligation or right. The second one is resolutory condition. Resolutory condition is one, the fulfillment of which will extinguish an obligation or right already existing. Before we discuss the examples for suspensive condition and resolutory condition, let us classify first the kinds of conditions. As to effects, we have suspensive, happening of which gives rise to the obligation, and the second one is resolutory, the happening of which extinguishes the obligation. To form, a condition may be expressed, which means that the condition is clearly stated in the obligation, or it is implied if the condition is merely inferred in the obligation. As to possibility, the condition is possible if it is capable of fulfillment legally and physically. It is impossible if the condition is not capable of fulfillment legally or physically. As to cause or origin, the condition may be potestative, which means that the condition depends upon the will of one of the contracting parties. It is casual when the condition depends upon chance or upon the will of a third person. It is mixed if the condition depends partly upon chance or upon the will of a third person. As to mode, the condition is positive if it consists in the performance of an act. The condition is negative if the condition consists in the omission of an act, meaning the condition consists in not doing an act. As to numbers, it is conjunctive if there are several conditions and all must be fulfilled. It is disjunctive if there are several conditions and only one or some of them must be fulfilled. As to divisibility, a condition is divisible if the condition is susceptible of partial performance. It is indivisible if the condition is not susceptible of partial performance. Now let us discuss what is suspensive condition, or we refer to as condition precedent or antecedent, antecedent. Suspensive condition is one the fulfillment of which will give rise to an obligation or right. For example, Mr. D obliges himself to pay $2,000 if Miss C will pass the law on obligations and contracts. In this obligation, you can see that the condition is if Miss C will pass the law on obligations and contracts. This kind of condition is suspensive because if Miss C will pass the law on obligations and contracts, the obligation of Miss D, or Mr. D rather, to pay Miss C 2,000 pesos will give rise or will take effect. On the other hand, if Miss C will not pass the law on obligations and contracts, then Mr. D will not be obliged to pay Miss C 2,000 pesos. Now let's go to resolutory condition, or we refer to as condition subsequent. Resolutory condition is one the fulfillment of which will extinguish an obligation or right already existing. This means that if the condition is resolutory, it has an opposite effect. For example, Mr. D obliges himself to give monthly support of 2,000 until Miss C graduates from college. From the start of the obligation, Mr. D is obliged to give a monthly support of 2,000 to Miss C, meaning to say the obligation has started to become effective upon the creation or the constitution of the obligation. Once Miss C graduates from college, then the obligation of Mr. D to give Miss C a monthly support of 2,000 pesos will be extinguished because here the condition is a resolutory condition, which, if fulfilled, will necessarily extinguish the obligation or right already existing. Now, let us distinguish between suspensive condition and resolutory condition. First, if the suspensive condition is fulfilled, the obligation arises, just like what we have given you as an example. On the other hand, if the resolutory condition is fulfilled, the obligation is extinguished. As you can see, there is an opposite effect if the condition is a resolutory one. Second, if the suspensive condition is not fulfilled, the juridical or legal tie does not appear, meaning to say, the obligation will not come into existence. On the other hand, if the resolutory condition is not fulfilled, the obligation continues and the tie of the law is consolidated. Just like the example we have given a while ago. If Miss C will not yet graduate from college, then the obligation of Mr. D will continue. Third, until the suspensive condition is fulfilled, the existence of the obligation is a mere hope. On the other hand, until the resolutory condition is fulfilled, its effects flow, but over it hovers the possibility of termination. Now let's go to impossible condition. Impossible condition is provided for under Article 1183 of the New Civil Code. Impossible conditions are those contrary to good customs, contrary to public policy, and those prohibited by law. Under Article 1183, impossible conditions shall annul the obligation which depends upon them. It means that the obligation shall not be valid. However, if the obligation is divisible, which means that it can be or it is capable of partial fulfillment, then the part thereof which is not affected by the impossible or unlawful condition shall be valid. The condition not to do an impossible thing shall be considered as not having been agreed upon. An example is A obliges himself to pay B 10,000 pesos if B will not smoke. Rather, if B will not fly. Take note here that the condition is if B will not fly. And that condition is an impossible thing because a person cannot fly. So, what does the rule says? It shall be considered as not having been agreed upon. So, meaning to say, the impossible condition, the condition not to do an impossible thing will be deemed not to have been agreed upon by the parties. So parang you disregard the condition not to do an impossible thing. So it's as if that the obligation does not have an impossible condition. Refers only to suspensive conditions. So Article 1183 refers only to suspensive conditions. It does not refer to a resolutory condition. It applies only to cases where the impossibility already existed at the time the obligation was constituted. Just like the example I have given a while ago. I will give you 10,000 pesos if you can fly. At the time of the obligation, or at the time the obligation was constituted, the condition is already impossible because, again, a person cannot fly. If the impossibility arises after the creation of the obligation, then Article 1183 will not apply, but Article 1266 governs. Now let's discuss the two kinds of impossible conditions. Number one is physically impossible conditions. And the other one is legally impossible conditions. Let us discuss first the physically impossible conditions. Under the law, physically impossible conditions when they, in nature of things, cannot exist or cannot be done. For example, Mr. D obliges himself to pay Miss C if she can fly. The condition in the given example is if she or Miss C can fly. Take note that, again, a human person cannot fly. Therefore, there is physical impossibility for Miss C to comply with the obligation to fly or with the condition to fly. Another examples. I will pay you 10,000 pesos if you can carry 20 cavans of palay on your shoulder. If you cannot carry 20 cavans of palay on your shoulder, then there is physical impossibility for you to comply with the condition. Second example, I will pay you 10,000 pesos if it will not rain for 1 year in the Philippines. Since it is impossible that it will not rain for 1 year in the Philippines, then there is physical impossibility for you to comply with the condition. Again, let's go back to the effect of impossible condition. Under Article 1183, it says that impossible conditions, those contrary to good customs or public policy and those prohibited by law, shall annul the obligation which depends upon them. So if the condition is impossible to do, then the obligation will not be valid. Second kind of impossible condition is legally impossible conditions, when they are contrary to law, morals, good customs, public order, or public policy. For example, Mr. D obliges himself to pay Miss C if she will kill X. Here, the killing of X is the condition in the obligation, and under the law, the killing of a person is contrary to law, meaning to say it is prohibited by law. Another example. So therefore, let's go back to the first example. If it is against the law, then Miss C has the legal impossibility to perform the condition. Another examples. Mr. D obliges himself to pay Miss C if Miss C will be the common law wife of X. This example is against morals, and therefore, Miss C will have the legal impossibility to comply with the condition. Another example, Mr. D obliges himself to pay Miss C if Miss C will slap his father, clearly against good customs. Third example, Mr. D obliges himself to pay Miss C if Miss C will publicly advocate to overthrow the government, clearly against public order. Lastly, Mr. D obliges himself to pay Miss C if Miss C will not appear as a witness against X in a criminal case, clearly against public policy. So these examples given are contrary to law, morals, good customs, public order, or public policy. In effect, the creditor has the legal impossibility to comply with the condition, or there is legal impossibility to comply with the condition. So, again, let's go back to Article 1183. What is the effect if the obligation has an impossible condition? Again, it shall annul the obligation which depends upon them, which means that the obligation will not be valid. Now let's go to potestative condition. What is a potestative condition? A condition suspense in nature and which depends upon the sole will of one of the contracting parties is known as potestative condition. For example, Mr. D obliges himself to pay Miss C if he feels like it. The potestative condition here is if Mr. D feels like it, meaning to say the fulfillment of the condition depends upon the sole will of Mr. D. if he feels like paying Miss C. So what is the effect of a potestative condition? The effect depends upon whether the potestative condition is dependent upon the will of the debtor or if it is dependent upon the will of the creditor. If the potestative condition is dependent upon the will of the debtor and the condition is suspensive in nature, for example, Mr. D obliges himself to pay Miss C if he feels like it, the law says that the obligation is invalid or void. On the other hand, if the potestative condition is dependent upon the will of the creditor, in the given example, Mr. D obliges himself to pay Miss C if Miss C feels like it. Then the law says that the obligation is valid. Let's go to casual condition. If the suspensive condition depends upon chance or upon the will of a third person, the obligation subject to it is valid. For example, Mr. D obliges himself to pay Miss C if Mr. D wins the lotto on September 7, 2020 draw. Here, if Mr. D has joined Lotto, and if he wins the Lotto on September 7, 2020 draw, then Mr. D's obligation will be effective and therefore valid. Here, the condition is depends upon chance because the winning in the lotto is a chance or a luck. Now let's go to mixed condition. If the fulfillment of the condition depends partly upon chance and partly upon the will of a third person, then the condition is a mixed condition. Under the law, the obligation is valid if the suspensive condition is a mixed condition. For example, Mr. D is a building contractor. On the other hand, Miss C is a building owner. Mr. D, a building contractor, obliges himself to repair the building at his own expense on any damage caused by an earthquake if found by a panel of arbitrators that construction defects contributed in any way to the damage. Here, the condition here is number one, if the damage is caused by an earthquake, which is dependent upon chance, because you are not sure, or it is not certain, no, if there will be an earthquake, so it depends upon chance. And the second condition here is if the defects are found by the panel of arbitrators be based on construction defects. So that condition is partly upon the will of a third person, which is the panel of arbitrators. And since this condition is dependent partly upon chance and partly upon the will of a third person, then the condition imposed in this obligation is a mixed condition. And since under the law, it is provided that if the suspensive condition is a mixed condition, then the obligation is valid. Now let's go to positive condition. Positive suspensive condition refers to the happening of an event at a determinate time, the effect of which will extinguish the obligation as soon as the time expires without the event taking place, or as soon as it has become indubitable that the event will not take place, although the time specified has not expired. For example, Mr. D obliges himself to pay Miss C if she will marry X before she reaches the age of 23. What are the legal implications of this based on positive suspensive condition? Number one, Mr. D is liable if Miss C marries X before she reaches the age of 23. Because the condition is if Miss C will marry X before she reaches the age of 23, the obligation will attach. Second, if Mr. D is not liable if Miss C marries X at the age of 23 or after she reaches the age of 23, because the condition is that Miss C will marry X before she reaches the age of 23. So if she marries X at the age of 23 or after she reaches the age of 23, then the obligation of Mr. D will not come into existence. Third, if Miss C dies at the age of 22 without having married X, the obligation is extinguished because it has become clear that the condition will not take place. Because again, Mr. D obliges himself to pay Miss C if Miss C will marry X before she reaches the age of 23. So if she dies at the age of 22 without having married X, then the obligation can no longer be performed, or the obligation is already extinguished because the condition can no longer be complied with. Negative suspensive condition. Negative suspensive condition, the condition is that an event will not happen at a determinate time. The obligation shall become effective and binding from the moment the time indicated has elapsed without the event taking place, or from the moment it has become evident that the event cannot occur although the time indicated has not yet elapsed. For example, Mr. D obliges himself to pay Miss C if she is not yet married to X on December 31, 2020. Mr. D is not liable if Miss C marries X on December 30, 2020 or prior thereto, because the condition is Miss C should not yet marry X on December 31, 2020. So if she married X before December 31, 2020, then Mr. D will not be liable. Second, Mr. D is liable if Miss C is not married to X on December 30, 2020, or if Miss C marries X after December 30, 2020. Third, if Miss C dies on November 20 without having married X, the obligation is rendered effective. Why? Because it has become certain that the condition not to marry X will be fulfilled. Kasi namatay na si Miss C. So therefore, she can no longer marry X. So the condition is already fulfilled. And therefore, Mr. D is liable to Miss C for the amount, there is no given amount. No? So the obligation will be effective. Now, what will happen here, because Miss C is already dead? Then the heirs of Miss C will have to receive the amount that Mr. D will pay to Miss C. Let's go to constructive fulfillment of suspensive condition. Under Article 1186, the condition shall be deemed fulfilled when the obligor voluntarily prevents its fulfillment. What are the requisites for the application of this provision? Number one, the condition is suspensive. You know already what is a suspensive condition. Earlier we said that a suspensive condition refers to an event, the happening of which will give rise to the obligation. Meaning to say, if the condition will be fulfilled, the obligation will become effective. Second requisite, the obligor actually prevents the fulfillment of the condition. Meaning to say, he stops the fulfillment of the condition. And the third requisite, he acts voluntarily. For example, X agreed to give Y a 5% commission if the latter could sell the former's land at a certain price. Y found a buyer who definitely decided to buy the property upon the terms prescribed by X. To evade the payment of the commission agreed upon, X himself sold to the buyer the property at a lower price, without the aid of Y. In this case, it can be said that the due performance by Y of his undertaking, the condition for the payment of the commission, was purposely prevented by X and is deemed fulfilled. Based on the fact that Mr. X himself transacted to the buyer without the aid of Y, even if it was Y who found the said buyer. So here, since Mr. X has voluntarily prevented the fulfillment of the condition, then the law says that the condition here is deemed fulfilled, and therefore, Mr. X is obliged to give Y the 5% commission. Now let's go to the retroactive effects of fulfillment of suspensive condition. Under Article 1187, the effects of a conditional obligation to give, once the condition has been fulfilled, shall retroact to the day of the constitution of the obligation. Nevertheless, when the obligation imposes reciprocal prestations upon the parties, the fruits and interests during the pendency of the condition shall be deemed to have been mutually compensated. If the obligation is unilateral, the debtor shall appropriate the fruits and interest received unless from the nature and circumstances of the obligation, it should be inferred that the intention of the person constituting the same was different. In obligations to do and not to do, the courts shall determine in each case the retroactive effect of the condition that has been complied with. In obligations to give, an obligation to give subject to a suspensive condition becomes demandable only upon the fulfillment of the condition. However, once the condition is fulfilled, its effects shall retroact to the day when the obligation was constituted. So what do we mean by retroact? It means that it will go back. The effect will go back to the day when the obligation was constituted. For example, on January 20, S agreed to sell his land to B for 50,000 pesos. Should B lose a case involving the recovery of another parcel of land, take note that the condition here is if B will lose a case involving the recovery of another parcel of land. And the obligation was constituted on January 20. Let us continue. On April 10, S sold his land to C. B lost the case on December 4. So based on the provisions of the law, once the condition is fulfilled, its effect shall retroact to the day when the obligation was constituted. So the condition here in the given example was fulfilled on December 4. Applying the provisions of the law, the obligation will, or the effects of the fulfillment of the condition will retroact to January 2020. However, there is a problem because on April 10, S already sold his land to C. So what will now be the resolution of this case? Before December 4, B had no right to demand the sale of the land by S because the condition was not yet complied with. However, when the condition was fulfilled on December 4, it is as if B was entitled to the land beginning January 20. Hence, as between B and C, B will have a better right over the land. It is required, however, under the property registration decree that the promise of S be annotated at the back of the certificate of title of the property to be binding against C. So, you have already known the effects, the application of the retroactive effects of fulfillment of suspensive condition. What about in obligations to do or not to do? Under the law, there is no fixed rule that is provided. Hence, the courts are empowered by the use of sound discretion and bearing in mind the intent of the parties to determine in each case the retroactive effect of the suspensive condition that has been complied with. For example, C obliged himself to condone the debt of D, his lawyer, should the latter wins C's case in the Supreme Court. In the given example, the condition here is if D wins C's case in the Supreme Court. And the obligation involved here is an obligation to do. In the given example, C obliges himself to condone the debt of D. In this case, upon the fulfillment of the condition, D shall not be entitled, C shall not be entitled unless the contrary has been stipulated to the earned interests of the capital during the pendency of the condition, as the intention of C is to extinguish the debt. Here, the fulfillment of the condition has a retroactive effect. So, if D will win the case in the Supreme Court, then it will have the effect of the condition, or the effect of the fulfillment of the condition will retroact to the time the condition, the obligation was constituted. So meaning to say, let us say, for example, the obligation was constituted in January 20, and D won the case in the Supreme Court in May 2020. Now, from January 2020 to May 2020, the obligation, the debt of D should have earned interest in between, di ba? Kasi di ba kapag nagpapautang ka, normally meron talaga yung interest. So from January to May, and based on normal, no, business transaction, meron talaga yung interest supposedly na nag-earn. However, because of this rule of retroactive effect, dahil napanalunan ni D yung kaso sa Supreme Court on May, sabi ng batas, it will have a retroactive effect. So meaning to say, yung obligation ni C to condone the debt of D will retroact on January 20. And therefore, ano yung effect? The effect is that the interest that should have earned between January 20 and May 2020 will not be earned by C. He cannot collect the interest in between January and May because of the retroactive effect of the fulfillment of the suspensive condition. But then again, it is the court that has the power. No, it has the sound discretion to determine if the fulfillment of the suspensive condition will have a retroactive effect. But if the court will find that the intention of the parties will not provide for a retroactive effect of the suspensive condition, then there will be no retroactive effect. Now let's go to retroactive effects as to the fruits and interest in obligations to give. By the way, you already know the meaning of obligations to give, right? Under previous discussions, previous provisions of the Civil Code, when you say obligations to give, it consists in the delivery of a thing, now whether movable or immovable. On the other hand, if the obligations is to do or not to do, it consists in the doing of an act or not doing of an act. So that's how you determine if the obligation is an obligation to give or an obligation to do or not to do. Now, let's talk about obligations to give now with respect to retroactive effects now as to the fruits and interest. In reciprocal obligations, there is no retroactivity because the fruits and interest received during the pendency of the condition are deemed to have mutually compensated. First, let us discuss what is reciprocal obligation. So, reciprocal obligations are those which arise from the same cause and in which each party is a debtor and creditor of the other, such that the performance of one is designed to be the equivalent and the condition for the performance of the other. So, it means to say that when you say reciprocal obligations, you are the debtor and creditor of each other. For example, I am your creditor, you are my debtor, and at the same time, you are my creditor, I am your debtor. So that is how reciprocal obligations, no? Or that is a reciprocal obligation. So under the law, if the obligation is reciprocal, with respect to the fruits and interest, there is no retroactive effect because they will be mutually compensated. For example, on January 20, S agreed to sell his land to B for 50,000 pesos. Should B lose a case involving the recovery of another parcel of land? So this example is familiar, right? Because we have already given this in our previous discussion. On April 10, S sold his land to C. B lost the case on December 4. When B lost the case on December 4, S must deliver the land and B must pay 50,000, right? S does not have to give the fruits received from the land before December 4, and B is not obliged to pay legal interests on the price since the fruits and interest received shall be deemed mutually compensated. So how will I explain this for better understanding? Diba, ang property, for example, yung property meron siyang mga coconuts. And the coconuts have fruits, right? The coconut tree will bear fruits. We call coconuts. What if, for example, during the pendency of the fulfillment of the suspensive condition, let us say from January 20 to December 4, S harvested, nag-harvest siya ng mga coconuts. Let us say yung worth ng coconuts harvested is 10,000 pesos. Now, on the other hand, from January 20 to December 4, during the pendency of the fulfillment of the suspensive condition, the 50,000 pesos price ng land could have earned interest or legal interest. Kasi mababayaran lang yan ni B kapag na-fulfill na yung condition. So, supposedly, from January 20, meron yung interest na tumutubo from the 50,000 pesos. But, on December 4, when the condition was fulfilled, sabi ng batas, S is not entitled to receive the legal interest on the price. On the other hand, B cannot demand from S the delivery of the fruits received from the land. No? In the given example, yung coconuts. Hindi niya pwedeng sabihin kay S na, Huy S, i-deliver mo sa akin yung coconut na hinarvest mo from January 20 to December 4. On the other hand, S cannot demand from B, sabihin niya, Hoy B, bayaran mo ako ng legal interest from January 20 to December 4. So, kasi ang sabi ng batas, yung mga fruits and interest na na-receive nila during the pendency of the condition are deemed to have been mutually compensated. Meaning to say, na-offset na yung dalawa. So, ano na lang yung matitirang obligasyon nila? Si S, i-deliver niya lang yung land at si B, bayaran niya lang si S ng 50,000 pesos. What about unilateral obligations? Under the law, there is usually no retroactive effect because the obligation is unilateral and gratuitous. For example, on January 20, S agreed to donate his land to B. Should B lose a case involving the recovery of another parcel of land, B lost the case on December 4. Upon the fulfillment of the condition, since this is a donation and not a sale, S has to deliver the land, but he has the right to keep to himself all the fruits and interests he may have received during the pendency of the condition, that is, from January 20 to December 4, unless a contrary intention by S may be inferred, as when it is stipulated that once the condition is fulfilled, S shall render an accounting of fruits received during its pendency. So the rule is, if the obligation is unilateral, the debtor shall appropriate the fruits and interest received. No? So, let us say, merong coconuts na hinarvest si S from January 20 to December 4. So, sabi ng batas, since this is a unilateral obligation, S can appropriate the coconuts for himself. And he is not obliged to deliver the coconuts to B upon the fulfillment of the suspensive condition. So what are the rights pending fulfillment of suspensive condition? So the rights of the creditor, he may take or bring appropriate actions for the preservation of his right, as the debtor may render nugatory the obligation upon the happening of the condition. Thus, he may go to court to prevent the alienation or concealment of the property the debtor has bound himself to deliver, or have his right annotated on the title to the property in the registry of deeds. This rule applies to obligations subject to resolutory condition. So, I will give you an example. The same example now given earlier. S obliges himself for a while. On January 20, let's go back to the example given. No? On January 20, S agreed to sell his land to B for 50,000 pesos. Should B lose a case involving the recovery of another parcel of land? On April 10, S sold his land to C, and B lost the case on December 4. So, applying this provision of the law, that the right of the creditor is that he can take or bring appropriate actions to preserve his right. So here in the given example, B here is the creditor of S, right? So while the condition is not yet fulfilled from January 20 to December 4, B can actually file a case against S in order to protect his right because S sold the land to C. So B can file an action to recover the land on the ground that B as a creditor has the right to take appropriate action to preserve his right in order to question the sale of S to C over the same parcel of land. Or if B will not file a case against S and C, B may annotate or cause the annotation of his right on the certificate of title of the land in the registry of deeds. Para makita doon na merong parang ang tawag niyan, affidavit of adverse claim. So, para makita doon na may claim si B over the parcel of land sold by S to C. Now, what is the right of the debtor? He is entitled to recover what he has paid by mistake prior to the happening of the suspensive condition. So, in the same example, what if, for example, S delivered the land to B even if the suspensive condition is not yet complied with or not yet fulfilled? So, ang right ni S is that he can recover what he has delivered by mistake. So, pwede niyang bawiin muna yung land from B. Kasi nga, the condition is not yet fulfilled. So, yan yung right ng debtor pending fulfillment of suspensive condition. Now, let's go to Article 1189, about rules in case of loss, deterioration, or improvement during the pendency of suspensive condition. So, ano lang ang ibig sabihin nito? What if, for example, yung thing or yung property subject ng obligation is nawala or na-deteriorate or may improvement? So, what will happen to the obligation if during the pendency of the fulfillment of the suspensive condition, there is loss, deterioration, or improvement? So, the article that will govern these instances is Article 1189. So, under Article 1189, when the conditions have been imposed with the intention of suspending the efficacy of an obligation to give, the following rules shall be observed in case of the improvement, loss, or deterioration of the thing during the pendency of the condition. Number one, if the thing is lost without the fault of the debtor, the obligation shall be extinguished, meaning wala nang obligation. If the thing is lost through the fault of the debtor, he shall be obliged to pay damages. Kasi kasalanan ni debtor, bakit nawala yung thing? It is understood that the thing is lost when it perishes or goes out of commerce or disappears in such a way that its existence is unknown or it cannot be recovered. So, etong this is a mere definition of lost of the thing. So, the thing is considered lost when it perishes, meaning to say, for example, food. Kapag nawala yung food or nag-expire yung food or naubos yung food, then na-perish ang food. Or goes out of commerce, meaning to say the thing can no longer be a valid object of an obligation. Or if it disappears, no, meaning nawala siya in such a way na hindi mo na siya mahanap or it can no longer be recovered. So these are the instances when we consider a thing lost. Third, when the thing deteriorates without the fault of the debtor, the impairment is to be borne by the creditor. Fourth, if it deteriorates through the fault of the debtor, the creditor may choose between the rescission of the obligation and its fulfillment, with indemnity for damages in either case. If the thing is improved by its nature or by time, the improvement shall inure to the benefit of the creditor. If it is improved at the expense of the debtor, he shall have no other right than that granted to the usufructuary. So let us give you an example of these instances. Now let's start with loss of the thing. For example, Mr. D obliges himself to give Miss C his car worth 100,000 if she will sell Mr. D's property. So take note that the suspensive condition here is if Miss C will sell Mr. D's property. What if, for example, the car was lost without the fault of Mr. D? Then, what is the rule? Under Article 1189, the obligation is extinguished and X is not liable to Y. Mr. D rather is not liable to Miss C even if Miss C sells the property. A person, as a general rule, is not liable for fortuitous event. What if the thing was lost due to Mr. D's fault? In the same example, if the loss occurred because of the negligence of Mr. D, Miss C will be entitled to demand damages. So for example, in the given case, then Miss C can demand 100,000 plus incidental damages, if any. Now, what if the thing deteriorates during the pendency of the suspensive condition? For example, Mr. D obliges himself to give Miss C his car worth 100,000 if she will sell Mr. D's property. If the car figured in an accident, as a result of which its windshield was broken without the fault of Mr. D, then Miss C will have to suffer the deterioration or impairment thereof, because the accident is not through the fault of Mr. D. However, if it was through the fault of Mr. D, Miss C may choose between rescission or cancellation of the obligation with payment of damages. In this case, Mr. D is liable to pay Miss C 100,000, the value of the car before its deterioration, plus incidental damages, if any. Or if Miss C does not want to cancel the obligation, then she may choose the fulfillment of the obligation, also with the payment of damages. In this case, Mr. D is bound to Miss C to give the car and pay 10,000 pesos, 100,000 pesos plus incidental damages, if any. For correction, by the way, let us say, for example, because of the accident, the value of the car deteriorated by 10,000 pesos, okay? I have not stated it in the problem, but let us say, for example, because of the accident, the value of the car was reduced to 90,000, thereby incurring damages of 10,000 pesos. Now, if, for example, Miss C will not cancel the obligation and chooses fulfillment of the obligation plus payment of damages, then Mr. D is bound to Miss C to give the car and pay the 10,000 pesos actual damages plus incidental damages, if any. Now, what if the thing was improved during the pendency of the suspensive condition? In the same example given, the example is the same, no? Mr. D obliges himself to give Miss C his car worth 100,000 if she will sell Mr. D's property. Now, suppose the market value of the car increased. What is the rule? The improvement shall inure to the benefit of Miss C. Why? Because the law says that if the improvement is by nature or by time, then the improvement shall inure to the benefit of the creditor. Since the increase in the market value of the car is an improvement by nature and by time. So, necessarily, Miss C will benefit from it. No? So Mr. D cannot demand payment, no, of the increase in the value of the car. However, if the improvement of the thing is at the expense of Mr. D, for example, Mr. D painted the car and replaced its seat cover at his expense, Miss C had no other right than that of a usufructuary. So this scenario is different, no, from the first one, because here Mr. D incurred expenses in painting the car and replacing the seat cover. So Miss C here cannot benefit as an owner over the improvement of the thing at the expense of Mr. D. Instead, she will have or she will acquire the right of a usufructuary. So what is usufruct? Usufruct is the right to enjoy the use and fruits of the thing belonging to another. So what are the rights of a usufructuary? Under the law, the usufructuary may make useful improvements or expenses for mere pleasure as he may deem proper, provided it does not alter its form or substance. But he shall have no right of indemnity therefore. So in this case, Miss C can introduce useful improvements to the car or expenses for mere pleasure, no, as a usufructuary. But she cannot demand reimbursement of what she has incurred, no, in improving the car, no, in this case, the car. The usufructuary may set off the improvements he may have made on the property against any damages to the same. So those are the rights of a usufructuary. Now let's go to effects of fulfillment of resolutory condition. Earlier, we discussed about suspensive condition, effects of fulfillment of suspensive condition. Now, let's go to the effects of fulfillment of resolutory condition. So it is provided for under Article 1190. Accordingly, when the conditions have for their purpose the extinguishment of an obligation to give, the parties, upon the fulfillment of said conditions, shall return to each other what they have received. So, di ba we said that in a resolutory condition, the happening of the condition will extinguish the obligation. So, upon the extinguishment of the obligation, the parties shall return what they have received. In case of the loss, deterioration, or improvement of the thing, the provisions which, with respect to the debtor, are laid down in the preceding article shall be applied to the party who is bound to return. So, meaning to say, Article 1189, yung kanina na pinag-usapan natin, will apply to the fulfillment of resolutory condition in case of loss, deterioration, or improvement of the thing. As for the obligations to do and not to do, the provisions of the second paragraph of Article 1187 shall be observed as regards the effect of extinguishment of the obligation. So you refer yourself to Article 1187. So let me give you an example of the effects of fulfillment of resolutory condition in an obligation to give. Mr. D allows Miss C to use his car until Mr. D returns from the province. So when you say resolutory condition, here, the obligation of Mr. D to allow Miss C to use his car is effective upon the constitution of the obligation. But it will be extinguished if Mr. D will return from the province. So, upon the return of Mr. D from the province, Miss C must give back the car. Kasi nga, sabi ng Article 1190, upon the fulfillment of the resolutory condition, the parties shall return to each other what they have received. So, kaya applying that particular provision of the law, then Miss C should give back the car to Mr. D. Now, let's talk about kinds of obligation according to the person obliged. So they are, number one, unilateral. It is unilateral when only one party is obliged to comply with a prestation, meaning one-sided, unilateral. Examples are donation, contract of loan, and comodatum. In a contract of loan, the lender has the obligation to give. After the lender has complied with his obligation, the debtor has the obligation to pay. Now, the second one is bilateral. When you say bilateral, both parties are mutually bound to each other, meaning to say they are both the creditor and debtor of each other. So we mentioned earlier about reciprocal obligation. Again, a reciprocal obligation or obligations are those which arise from the same cause and in which each party is a debtor and creditor of the other, such that the performance of one is assigned to be the equivalent and the condition for the performance of the other. An example is a contract of sale. Because in a contract of sale, the parties are reciprocally bound to comply with their respective obligation. So, kailangan kaliwaan. When you say reciprocal, kaliwaan yan siya. So, kapag mag-contract of sale, kailangan si seller, i-deliver niya yung property na binibenta niya at the same time, si buyer, bayaran niya yung amount ng property. Non-reciprocal obligations are those which do not impose simultaneous and correlative performance on both parties. For example, X borrowed from Y 5,000. Y, on the other hand, borrowed X's car. The performance by X of his obligation to Y is not conditioned upon the performance by Y of his obligation and vice versa. Although they are both creditor and debtor of each other here, but the object of the obligation are, or the objects of the obligation are different. With respect to X, his obligation is consists in the sum of money, which is 5,000. But with respect to Y, his obligation is or consists in the delivery of a car. So, meaning to say, the obligation is not reciprocal. So, X cannot demand from Y the delivery of the car even if X had already paid the 5,000 pesos and vice versa. So what are the remedies in reciprocal obligations? Now, under Article 1191, the power to rescind obligations is implied in reciprocal ones, in case one of the obligor should not comply with what is incumbent upon him. The injured party may choose between the fulfillment and the rescission of the obligation with the payment of damages in either case. He may also seek rescission even after he has chosen fulfillment if the latter should become impossible. The court shall decree the rescission claimed unless there be just cause authorizing the fixing of a period. This is understood to be without prejudice to the rights of third persons who have acquired the thing in accordance with Articles 1385 and 1388 and the mortgage law. So let us discuss by illustration. Mr. D sold his car to Miss C. It was agreed that Mr. D would deliver the car and the necessary documents to Miss C's residence on September 7. And Miss C would deliver the payment at the same time and place. So here, the example is a reciprocal obligation because this is a contract of sale. If Mr. D will not comply with his obligation to deliver the car and the necessary documents, then Miss C may, in an action for specific performance, demand the delivery of the car with damages. So Miss C can choose to apply fulfillment with damages. Or if she does not want the fulfillment of the obligation, then she may demand from the court the rescission of the contract, also with damages. We have already discussed earlier now what is fulfillment with damages and rescission with damages. When you say fulfillment with damages, you are demanding that the car will be delivered and the necessary documents, plus payment of incidental damages, if any. When you say rescission, it means that you wanted to cancel the obligation. You do not want to enter into a contract of sale anymore because you want to cancel it. And again, if you want to rescind the contract, you are also entitled to the payment of damages. Remedies in reciprocal obligations. What are the principles to remember here? Take note that the remedies are alternative. Di ba we said that there are two remedies. Number one, you can ask for the fulfillment of the obligation with payment of damages, or you can seek the rescission of the contract with payment of damages. Sabi ng batas, you can choose only one. The remedies of the injured or aggrieved party are alternative and not cumulative. That is, he is privileged to choose only one of the remedies. Exception, when after choosing the fulfillment of the obligation, the fulfillment thereof becomes impossible, then the injured or aggrieved party may also seek rescission. But after choosing rescission of the obligation, he cannot demand thereafter the fulfillment of the obligation. So, second principle, there are limitations on the right to demand rescission. Meaning to say, the right to demand by the injured party is not absolute. Because number one, you should file a case in court for you to demand the rescission of the obligation. The rescission contemplated by Article 1191 is a judicial rescission or one granted by a court. The injured party has to resort to the courts to assert his rights judicially. For the same article provides that the court shall decree the rescission claim unless there be just cause authorizing the fixing of a period. Under the law, no person can take justice or the law in his own hands and decide by himself what are his rights in the matter. The other party must be given an opportunity to be heard. So, if you wanted to rescind the obligation, you should file a case in court for rescission. You cannot just rescind it automatically because you cannot take the justice or the law in your own hands. And you should give the other party an opportunity to be heard, meaning to say, an opportunity to explain why he failed to fulfill with his obligation. However, there are exceptions to the rule. Number one, when there is an express agreement between the parties, meaning to say, the creditor and the debtor agreed that if they wanted to rescind the obligation, there is no need to go to the courts. They can automatically rescind it, provided a written notice is given. Or where the contract is still executory, meaning to say, none of the parties had complied with what is incumbent upon them. Meaning, wala pang nag-comply ni isa sa kanila. So, meaning to say, you can rescind the obligation even without filing a case in court. The second limitation is the power of court to fix period. The court has discretionary power to allow a period within which a person in default may be permitted to perform his obligation if there is a just cause for giving time to the debtor, as where the debtor incurred was not willful, or the default incurred was not willful or could be excused in view of the surrounding circumstances. Third, right of third person. If the thing subject matter of the obligation is in the hands of a third person who acted in good faith, rescission is not available as a remedy. Fourth, substantial violation. The general rule is that rescission will not be granted for slight breaches of contract. Meaning to say, if the breach is only slight, it is not that grave breach, no, or grave violation, then you cannot ask for the rescission of the contract. The violation should be substantial as to defeat the object of the parties in making the agreement. Thus, in a case, it was held that delays on 4 occasions in the payment of rentals for a few days were not substantial violations in a contract of lease to justify rescission because the law is not concerned with trifles. So, if for example, you just failed to pay for monthly rentals daw in a contract of lease, hindi daw siya considered as substantial violation. And therefore, you cannot ask for rescission. And last limitation, waiver of right. The right to rescind may be waived expressly or impliedly. Thus, the acceptance by the seller of the land sold as security for the balance of the price is an implied waiver of the right to rescind in case of non-payment by the buyer. His remedy is not rescission, but to recover the balance of the price. Where both parties are guilty of breach. So what is the rule? Under Article 1192, in case both parties have committed a breach of the obligation, the liability of the first infractor shall be equitably tempered by the courts. If it cannot be determined which of the parties first violated the contract, the same shall be deemed extinguished, and each shall bear his own damages. For example, S sold his television set to B. The agreement states that S should deliver the set to B on September 7, 2020 at the house of B, and payment shall be made by B upon delivery. S did not deliver the set on September 7, in spite of a demand made by B. 5 days later, S delivered the set, but B incurred in delay in paying the purchase price. So what will be the rule here? In a suit between S and B, the liability of S for damages should be equitably tempered by the court, taking into consideration the breach also of the obligation on the part of B. So, who is the first infractor here? The first infractor here is S because he failed to deliver the set on September 7 in spite of a demand made by B. But 5 days later, when S delivered the set, B failed to pay the purchase price. So, the second infractor is B. So, ano ang sabi ng Article 1192? The liability daw of S will be equitably reduced or tempered dahil meron ding violation si B as a second infractor. However, if both allege that the other was the first infractor and the court cannot determine who of the two is telling the truth, the contract shall be deemed extinguished and each shall bear his own damages. This means that the contract shall not be enforced. So, if for example, nag-away sila at there is an issue kung sino ba talaga ang first infractor. So, at kapag walang ebidensya kung sino yung first infractor, then sabi ng batas, extinguish na yung obligation. And each shall bear their own damages. So, that will be all for pure and conditional obligations. For the other kinds of obligations, we will have a separate video for them. Thank you and good evening.